So this will just be a quick narration to go with the PowerPoint presentation in case you missed it. And hopefully this will be a little bit more helpful for you. So we're talking about the 6th and the 8th Amendments and some of the 5th. So let's get started here. First thing we need to talk about really is your right to counsel. And this was provided in Gideon versus Wainwright. And at the federal level, you had always had the situation where the federal government would provide you with legal counsel if you could not provide one for yourself. But in Gideon versus Wainwright, that got selectively incorporated down to the state level as well. And so then, in essence, the states would have to provide counsel if you could not afford one yourself, where before the states said they didn't have any constitutional mandate to do so. But the judges, in essence, ruled that in order to have a fair trial, it's important that you have legal counsel that can navigate that kind of a system, because the average person is unable to provide that for themselves. They just don't have the skill or expertise to do that. The next thing we should look at really is excessive bail, and this in many ways is a bit of a holdover from kind of older times in England, when kings used to and judges used to set bail that they knew that people would never be able to pay, and that was another form of not having necessarily to charge somebody or imprison somebody through prosecuting them, but they can in essence just hold them in jail, because those people would never have the ability to pay for bail and get out of bail. So really what happens is the amount of bail set must bear some relationship to, number one, the gravity of the offense. I mean, if we're talking about a small crime here, probably no bail, but if it's a bigger crime, a more serious crime, then bail goes up, because in essence, the likelihood of a flight risk, right? If you've committed murder or up on murder charges and you think that you might get convicted of that, if you're out on bail, there's a risk that you may very well flee the country or flee the state and try to get out of there. So they're going to set bail high enough to make it very, very difficult on you. They may even deny bail in certain situations, and the denial of bail altogether is not against the Constitution in terms of excessive bail. There are many reasons why. Some are, depending on the severity of the crime. Sometimes if you were out on probation or parole and you violated that as a result of this new arrest, then they may, in essence, just not even offer bail as an option. If you're not a U.S. citizen, that would mean you may leave the country, and so they would deny you bail sometimes in those situations. And sometimes if you pose a threat to the public, let's say you are possibly going to commit more crime while you're out on bail, then they may determine not to send or allow for bail in that case. And in those circumstances, it would not be against the Constitution to deny you bail in that sense, and it would not be excessive in that way. The next thing we should look at, speedy and public trial. The first provision protects against unreasonable delays. Courts do get backed up, but this doesn't really apply to that. But in terms of, we'll bury you in the system and let you kind of rot there, and we'll just make it take a really, really long time before we can get to your trial, and that's a form of punishment. And so to protect against that, you must have a speedy trial, with the caveat that as speedy as possible, right? We do not have enough judges. The court system is very, very backed up, and as a result, they need to move with all haste and speed that's possible. So it doesn't mean there isn't delays, but you should have some relief within a reasonable amount of time. You can kind of see from up here, and this is in New York, if you committed a felony, your trial must be conducted within 6 months, misdemeanor 90 days, a misdemeanor punishable up to 3 months in jail, so kind of a smaller misdemeanor within 60 days, and then just a random violation, a smaller violation, your trial needs to be within 30 days. And so they've set some basic limits there for you. The second provision bans the government from conducting trials in secret. And the point of that is we need to make the public aware, allow media and the press to conduct sort of investigations, or at least be present to make sure everything is kind of on the up and up, and prevent any kind of judicial abuse that might occur as a result of them being able to make judgments and rulings without any witnesses to hold them accountable for that. So that's another provision that we've got going here. Now, we should talk about grand juries and grand jury indictments, because what a grand jury does is it's different from a trial jury, where a trial jury sits on a criminal trial, they hear the case, and they're the ones who come up with the verdict of guilty or innocent. A grand jury, in essence, looks at the evidence provided by the prosecutors and looks at that to determine whether or not there is enough evidence to decide whether or not a trial should even move forward. And so before you ever get indicted or charged with a crime, a lot of times a grand jury will look at kind of the facts of the case and the evidence that's been collected and decide whether or not there is probable cause that a crime was committed and that you actually caused that crime. And so what the grand jury does is look at that and do that kind of work. Grand juries usually sit anywhere from 12 to 18 months. They don't meet every day. They meet a couple days a week or even once a week or something like that to hear certain kinds of cases and look at the evidence and make determinations on whether or not they will move forward to indict somebody. And so it's not like sitting on a trial case where you sit there and you're on that case until the case has been decided. So it's a little bit different that way. There really are two types of grand juries. There's an investigative type of grand jury. Once again, meet once a week for about 18 months or longer, but they look at one or two cases at a time. These typically are your bigger cases. They really kind of dive in and look at all of the information there and evidence provided and those kinds of things. And every once in a while, they'll hand out an indictment or not based on the cases that are sitting in front of them. And then there are what we call reactionary grand juries, where same kind of deal, usually meet once a week for 18 months, something like that. But they look at smaller cases and they look at many cases that kind of come before them as they come up, and they will look at the evidence provided in those cases in a much more quick fashion because they're lesser cases, they're not as big, and they'll make a lot of different calls on whether or not to indict people who have been recently arrested and those kinds of things. So just kind of a difference in grand juries there. So to continue on with grand juries, usually by moving through this grand jury system, really what it's doing is it's kind of preventing the state from bringing cases against individuals in maybe a frivolous manner, because now it brings another set of eyes onto the case and requires that there is enough substantial evidence, that there is probable cause, that you have enough evidence to actually charge somebody and allow the case then to move forward. So kind of prevents frivolous government cases. It is a requirement in federal cases, but it's not a requirement in state cases. And certain states have their own requirements or provisions for grand juries. Some states have provisions and don't use them. Some states use grand juries. So it's really kind of left up to the states to do this. This idea of using a grand jury has not been federalized to the states, so in essence, it hasn't been selectively incorporated down to the state level. And there, in terms of due process and those kinds of things, it's not unconstitutional if a state doesn't use a grand jury in this kind of a thing. And then some charge that the grand jury has merely become a tool of prosecutors, meaning that prosecutors, in essence, can provide the evidence they want, and there were a lot of claims that juries just, in essence, whatever the prosecutors wanted, the grand juries would, in essence, do that bidding. There was even a judge who claimed at one point in New York that the New York grand jury would indict a ham sandwich. Obviously, being sarcastic, but saying how easily the grand jury, in essence, would indict other people. So there is some of those cases. It's not necessarily the case, and we hope that grand juries are a little more legit than that. Now, a trial by jury is guaranteed in criminal cases, and so that too is a holdover from the Old English days when kings would, in essence, throw people in jail, and people were not given a real opportunity or a chance to be heard from their peers who might at some point in their lives be in the same situation. And so that was one of the things that they kind of forced upon King John when they were signing the Magna Carta. And in essence, look, people who could possibly be in my position and are just like me, they should be able to hear my case, and I should be tried by those people as opposed to a ruler or a judge who is not in my situation. So it's guaranteed in criminal cases, guaranteed, I should say, in federal cases, worth more than $20. So at the federal level, it's not just criminal cases, but it can also be civil cases. So any civil case, a lawsuit or whatever it might be that amounts to over $20, there also is a trial by jury. So a little bit different there. Once again, no requirement at the state level for this. It's kind of a thing, except for in criminal cases. Let's look at witnesses. So anybody who has been accused of a crime and is a suspect at trial has the right to bring witnesses on his or her behalf, and even if those witnesses don't want to, testify on on the suspect's behalf, the courts can issue a subpoena, in essence, which is a court order to force the witness to come to trial and testify. And if the witness refuses to testify, then the court can hold that witness in contempt of court as a hostile witness, and in essence levy possible charges against that witness until they do testify. And the suspect also has the right to confront witnesses who may have been brought before them by the prosecutors and allow them to cross-examine, in essence, what those witnesses have to say. And so that all allows for openness in trials and allows a much more fair trial in that sense. Cruel and unusual punishment. Sometimes we think in terms of the death penalty, and that certainly is one of the more controversial issues. But cruel and unusual punishment, it's an Eighth Amendment issue, and it was banned by the Eighth Amendment. And the idea is the punishment must be proportionate to the crime. Somebody steals something, you probably cannot cut an arm off for that. It has to be proportionate. And the idea behind it is we shouldn't be punishing or taking revenge on people for committing crimes. We should be doling out consequences that, in essence, will prevent crimes like these from happening in the future, but it shouldn't be a way to get revenge. And so that's kind of the idea behind no cruel and unusual punishment. The death penalty has been ruled that it is not cruel and unusual. But in the Atkins versus Virginia case, as we've seen, the mentally handicapped or minors, because of their lower capacity to understand the true magnitude of their crimes, they can't be held to that same standard as a sane person or as a regular mental capacity person, something like that, because they just don't have that same capacity, and that's been ruled by the courts in Atkins versus Virginia. California's three strikes law, that's another interesting one in terms of cruel and unusual punishment. If you're caught with marijuana 3 different times, now you're thrown in prison for life. Is that considered cruel and unusual? It sounds like, hey, we've tried to prevent you from doing this through jail terms or other things earlier, but you've done it, multiple times. You're done. The U.S. Supreme Court in 2003 upheld the three strikes laws as not cruel and unusual punishment, but there's been some backlash around that. In California, we voted it out. Partly as a response to overcrowding in prisons and our prison system becoming too expensive and in essence having tons and tons of people being incarcerated for life who have done very nonviolent and pretty small crimes, but they've done them a number of times. So think in terms of two reasons why would the prison system be political advocates for a three strikes law. They are a pretty heavy advocate to have this three strikes law. Number one, I think you've got people who are in law enforcement. Clearly they're trying to clean up the streets and they don't like to see repeat offenders and feel like, hey, we're doing this work and we somebody gets thrown in jail for 3 months and then they're back out on the streets and they're committing the same crimes. We want to take them off the streets and we want to make society safer, and clearly these people are not going to stop what they're doing, and that's more of a philosophical issue, but I think there's also a financial issue that people would argue around this. When you create a prison system that gets larger and larger, that employs people make money off of that. We have a private system that is in essence a for-profit system, and there's been some abuse and corruption in those systems recently, we've heard in the news. And so there's money to be made in the prison system, and the more people you incarcerate and keep them there for longer periods of time, the more money you're going to make and those kinds of things. So there's also a financial reason why the prison system may be sort of on board with this, and that's a little bit tougher to prove, but that is one of the big arguments at this point in time. We should talk about double jeopardy. A person may not be tried a second time for the same criminal offense if found not guilty. You can't send that back to trial and bring that back up and retry people in essence until they are found guilty. There are a couple of different exceptions to this. So if a crime violates both a state and a federal law, then both the state can prosecute and the feds can prosecute. And so in essence, it's not really double jeopardy in that sense because you're going through two different systems at that point. And so you can be for both crimes. And then when there is a mistrial, there was a mistake made in the trial in some way, improper evidence was introduced or some other reason why it's considered a mistrial, you're going to go through the trial process again and hopefully in a much more fair way. And sometimes you end up in a situation where the jurors cannot come to a unanimous decision, otherwise known as a hung jury, and they can't come to a verdict. You're going to have to go through that trial process again and get a new jury to try that until we can either decide innocence or guilt. But it, in essence, has to be unanimous. So those are a couple of exceptions to where you could be tried more than one time. And that concludes our presentation on the 6th and 8th Amendment.